Good evening, everyone. So last time we met, we were discussing medical malpractice, and we indicated that there are various causes of action which are available to a victim of medical malpractice. So we've so far discussed the criminal prosecution, which will be brought at the instance of a victim of medical malpractice for some limited instances where it is permissible for you to sustain a successful criminal case. Then we've also looked at the various types of civil actions, such as action for clinical or medical negligence. You've also looked at the action for breach of contract or action for trespass of the person, as in battery and assault. And again, we've also looked at the professional disciplinary proceedings, which may be brought against a professional who is alleged to have been responsible for particular medical malpractice. And we also talk about human rights enforcement action that in appropriate cases where the particular malpractice you are claiming or complaining of could be framed as a human rights issue, then could actually pursue the type of cases or action which one may embark upon for enforcement of human rights. Now, having outlined these various forms or courses of action available to a victim of medical malpractice, we started by discussing clinical negligence or medical negligence. And with respect to clinical negligence or medical negligence, we made the point that to be successful, you need to be able to establish the usual requirements. That is, you need to show that the particular healthcare practitioner owed you a duty of care. And again, we also said that it is not enough to show that there was a duty of care, but more importantly, you should show that with respect to the particular treatment, diagnosis, or procedure, whatever in question, there was a breach of that duty of care. And for that matter, you have suffered a certain injury. So there must be a consequent injury or resultant injury, as it were. And we noted that these three elements are conjunctive in the sense that you must be able to establish all of them before you can succeed in an action for breach of, an action for negligence or clinical negligence, as it were. Then we proceeded to take them one after the other. So we first decided to explore when and how can we say that the patient was owed a duty of care. In other words, when can the patient say that the healthcare professional owed me a duty of care? Now, with that, we said that the position of the law has been made clearer since the famous Lord Atkin view in the case of Donoghue and Stevenson, that if we can establish the situation of proximate relationship, that is a neighbor principle, then we can say that a duty of care was owed. Of course, in the case of a clinical context between the doctor and the patient, it's not really difficult for you to demonstrate that the patient and then the doctor were in such relationship that the doctor or the healthcare professional, for that matter, ought to have had the patient in care when acting, so that his or her action will not have adverse effects on the patient. So that is pretty straightforward, as we noted, to establish that a duty of care was owed to the patient. But we also noted that even in those type of situations where it appears some kind of a novelty, or like it's new, in the sense that the court has probably not come to conclusion using even like the Donoghue and Stevenson reasoning that a duty of care existed. It is still possible for the court to recognize a duty of care using the Caparo text. That is the principle that we saw enunciated in the Caparo and Dickman. Of course, in that case, the court will actually look at whether in that new situation, it is reasonable, it is just for a duty of care to be recognized. If that can be established, then the court will say that a duty of care exists in that new situation in which it has never been recognized that a duty of care, for example, was owed. So in that respect, we notice that we are basically using the same traditional principles of tort of negligence to try and advance issues of medical negligence or clinical negligence. Then we ask a question, who can the patient sue? Who can the patient sue? And we noted that ordinarily the patient will see the particular medical professional who is the primary tortfeasor. That is the person who actually caused the tort or the injury that the patient is complaining about. But in practice or in reality, because the healthcare professional will not be working on his own, he may be working for a healthcare facility. It will be prudent for you to sue the healthcare facility as an employer, in which case you are suing on basis of what they call like the vicarious liability, because of the existence of the employment relationship between the healthcare professional alleged to have committed the particular medical negligence and the owner or the facility that the healthcare professional is working for. We saw that. And again, we've also noted that it is quite apart from having a cause of action against the healthcare professional. Against the facility, the hospital, on basis of vicarious liability. It is also possible for the facility or for the hospital to be sued directly for having owed the patient a duty of care. So if you remember, we look at those cases where, for example, a hospital which to all intents and purposes presented itself as having been opened for service and patient was rushed there and it appears they were actually not working and things went wrong. The court said that yes, a duty of care was owed and all that. So in that case, the hospital is being held directly, if you like, the liable, not because of vicarious liability. So we notice that at least there are two ways in which the particular hospital or health facility could be made liable, either because the healthcare professional who is at the center of the alleged malpractice was an employee of the hospital, which is usually the case oftentimes, or the hospital itself, for example, failing to put in place the necessary system or arrangement for its services to be available to a patient, could also be held liable or could be said to owe the patient a duty of care, as it were. And we look at a number of instances, and even where a hospital, for example, has transfused a blood, which is infected with HIV, as remember the rare HIV hemophiliac litigation. Even in that case, the facility was said to owe the patient a duty of care as it were, and so on. Then again, I think that was the place that we ended, and we're going to start what we call the breach of duty of care. So we would like to continue with our joint class by discussing the breach of the duty of care. So the second major element in trying to establish whether there has been clinical negligence or not is to show that whether there was a breach of duty of care. And as we know already from law of tort, this requirement is also very important, because if you simply establish that the patient was owed a duty of care, you haven't really done anything. Yes, he was owed a duty of care, but you haven't shown that the healthcare professional, and for that matter, the particular hospital, breached that duty of care. So that is what makes the breach of the duty of care important. Now, to start with, establishing breach of duty of care is a duty of the patient. It's a duty of the patient, because we know that according to our law of evidence, he who asserts must what? Must prove. I hope you remember that. He who asserts must prove. A incubit oratio probato. So the person who's asserting that something exists or something does not exist, he or she bears the burden to actually bring evidence to establish that that which he is talking about is the case or is not the case. So, for example, if you go to section 10, if you go to section 10, section 11, section 12, and section 15 of the Evidence Act 1975, NRC Decree 323, the import of these provisions is that the person who is making the allegation that something happened or something did not happen, that person has the burden to bring requisite evidence, which in the mind of the tribunal of fact, that is the court, will be persuaded that it is more probable than not that what you are alleging happened or did not happen, as it were. So now we know who bears the duty of care. It is a patient that bears the duty of care. Good. But how can the breach of the duty of care be established? To establish the breach of the duty of care, we need to first have what we call the standard of care. Because anytime you are saying that someone's action or someone's omission fell short of the standard, fell short of a particular care expected of him, that in itself presupposes that there's a certain standard, right? There's a certain yardstick which the person was supposed to live by, which the person was supposed to conduct himself by, and he or she, for example, did not do that. And that is why you are saying that there was a breach of duty of care in that particular case, as it were. Yeah. So, to talking about breach of duty of care, we must first ask ourselves, what was the requisite standard of care to which the healthcare professional should have actually met, and that we're saying that he failed to meet. So that is the first thing that we have to talk about. Now, in the normal tort law, we know that the duty of care is what we call the reasonable man rule standard. In other words, what the reasonable man will have done, or what the reasonable man will not have done. That is what is usually called the standard of care in trying to establish whether there has been a breach of duty of care or there has not been a breach of duty of care. But in this regard, we must remember that the court does not make any allowance for inexperience. It doesn't matter, so long as you've held yourself as having a particular skill. The court will not say that because you were less experienced, we are going to expect something lower than what is usually the case. As you saw, for example, in the case of nettleship against Weston, if you remember from your law of tort, a learner driver, for example, was deemed to have the same skill as an experienced driver, and that no recognition could be made of the fact that she was a learner driver. In other words, once you put yourself on the road, you run into somebody's car, and so long as you've done that, it's no defense to you that you're a learner driver. If you're a learner driver, you don't go to the highway, isn't it? But once you are there, then you'll be held to the particular standard. In the same vein, if you come directly into the medical or the clinical setting, if you remember the old case of Wilshire against SS Area Health Authority, for example, you notice that the court, please, the citation I have here is wrong. It's 1986 rather, not 1897. In any case, in 1897, there was nothing like the NHS. Yeah, so for example, if you look at the Wilshire against SS Area Health Authority, the English Court of Appeal had to decide liability of a junior staff in the hospital. A premature baby had been improperly treated. If she had been properly treated, definitely the baby will have survived. The baby needed oxygen in order to survive, but on 2 occasions, the baby was given excessive amount of oxygen, and the defendant doctor in the hospital argued that the staff that managed the baby patient were inexperienced. They did their best in the circumstances to try and save the situation. But the Court of Appeal said that inexperience was no defense, right? Yes, it is possible that you can learn on the job, but it was no defense to say that they were inexperienced. For that matter, they should be exculpated from liability. If you have an inexperienced doctor who is still undergoing training, he must always be in a team of experienced doctor. You don't leave the doctor on his own. There's a case involving a certain hospital in Ashanti region, for example. It has to do with what do you call the emergency cesarean session because of certain mistakes which the junior officer or the houseman had actually created. And if you look at it, the procedure that the particular doctor who initially created the trouble, indulging was such that it ought not to have been the case. And that procedure should have been done under the guidance of a more experienced a medical officer in that particular hospital within the district, as it were, but that was not the case. So the takeaway from Wilshire against SS Area Health Authority is that, yes, much as the court recognized that learning on the job is permissible, it is no defense when a case of negligence has been brought to argue that the particular healthcare professional was inexperienced. And for that matter, the inexperience should be a mitigating factor regarding the liability of that professional. That is no defense at all. So let us look at that in mind. Another point to note, generally speaking, as far as negligence is concerned, the standard of care, is what Lord Denning said in the case of Roe against Minister of Health, when Lord Denning said that one cannot look at 1947 accident with 1954 spectacles. I mean, that is quite poignant. That is to say that when we are talking about the standard of care, even in the normal thought, we are talking about the standard of care which pertain at the time that the tort was committed, right? The standard of care which was enforced at the time that the tort was committed, and not at the time that there has been a complaint of negligence. What do I mean by that? Let's suppose that you went for the particular medical procedure 2 years ago, and now something has gone wrong, you've sued the hospital, and 3 years later, you are going through trial. Let's suppose that in the medical field, there has been some new development so that the procedure which was used 2 years ago is no longer considered a good procedure. And we have like a new procedure and all that. So where that is the case, what Lord Denning is saying is that insofar as at the time that the incident happened, it was that procedure which was enforced and not any other. Yeah, sorry, my line went off. Yeah, so when a case has been brought, it is not the current procedure or the new procedure in place which is going to be used in trying to determine the standard of care expected of the healthcare professional with respect to the particular medical negligence which has come before the court. So let us keep that in mind. The court will use that which was enforced at the time that the incident occurred. And that is why there is so much wisdom in the aphorism attributed to Lord Denning in Rome. Yeah, sorry for the internet challenges. The morning when I had a class the first year, the internet was very good. I don't know why it's misbehaving tonight, but let's manage what we have in the circumstances. So I'm just making the point that Denning's wisdom is quite instructive, that you don't look at 1947 accident with 1954 spectacles. In other words, if the accident that you are complaining about happened in 1947, and now the trial is taking place in 1954, there have been so many developments, you don't use the current standards to judge that which happened about 7 years or so ago. So that is the point that is trying to say, and that is applicable to medical negligence as well. And in fact, if you look at the decision in Al against West Midlands South Health Authority, you notice that the court actually followed the same approach by denying in rule against of health that you cannot use the new standard to judge that which occurred before the new standard came into being. So let us keep that in mind. But as far as the medical negligence is concerned, it is true that we use the reasonable man standards. However, in 1957, what a case that you all know very well, the case of a Bolam against a Farran Hospital Management Authority, a management committee, in which Justice McKnight gave a very interesting direction to the jury, which was doing the trial. Don't forget, in those days, some of the cases were a jury trial. And the direction that he gave to the jury metamorphosed into what is now known as like the Bolam test. So that if you talk about like a medical negligence, we have to find out whether the particular doctor met the Bolam test or did not meet the Bolam test as it were. And what is the Bolam test? Now, as you know, in around the late 1950s, there was Mr. Bolam. He underwent electroconvulsive therapy, right? ECT treatment, something for sickness related to what do you call it? The mind, the nervous system, and all that. And the treatment that he underwent, he was not restrained. In other words, they did not put anything to hold his firm, so that as the electrical shocks, that is the electroconvulsive therapy, was administered, he would not fall off and injure himself and all that. He was not restrained. And eventually, he got injured in the process. So he sued the healthcare professional, for that matter, the hospital, for negligence in treating him. And in his view, he ought to have been restrained, or he ought to have been made aware, and so on. So he thought that that was a substandard care. Now, in the course of the trial, the judge needed to direct the jury concerning this particular matter. In other words, the jury was to make up its mind as to whether, in its view, the failure by the doctor or the hospital to actually restrain the patient can be considered as amounting to breach of duty of care. So it was in that context that the judge, in directing the jury, told them that, as to whether what happened fell short or did not fall short, they should know that, quote, the test is a standard of the ordinary skilled man, exercising and professing to have that special skill. A man need not possess the highest skill at the risk of being found negligent. It is well established that it is sufficient if he exercises ordinary skill of an ordinary competent man exercising that particular act. I mean, for the first part, that was quite straightforward. He exercised or he established the principle that we know very well. However, as you read on, the judge will make the point that the doctor or the healthcare professional should not be held liable for having breached a duty of care if he or she conducted himself in a manner which a responsible body of medical opinion will have actually endorsed. In other words, if what he did, we had a reasonable body of doctors who have done it in the same way, then the particular doctor cannot be held liable for a breach of duty of care. It did not matter that there were some other Yeah, so I was just making reference to the statement of the standard of care in the Bolam case by Judge McNally. So he, among other things, said that, quote, a doctor is not guilty of negligence if he has acted in accordance with the practice accepted as proper by a responsible body of medical men skilled in that particular act. Putting it other way around, a doctor is not negligent if he is acting